Everybody. Welcome to our very final live stream of 2020. What a year of streams this has indeed been. I can't even count up how many we've done. A lot. And of course, if you want to catch up on any of those that you did or didn't see since we began this wild live stream adventure in 2020, please visit our YouTube channel. We've got all the live streams, including from Journalism Under Fire. They're all there for you. This, of course, is the giving season, and we would love to have your ongoing support of CIR. Of course, giving the gift of membership is just such a wonderful way of sharing your love of CIR and also your love for educating the next generation. As many of you know, indeed, our membership dues do go to support our students, to ensure that they get the doors opened into this amazing world that we have just as much as you and I have had over the course of our time together. So please do so. Giving the gift of membership, giving just a plain old donation to CIR, which we always enjoy, is super easy and available on our website at sfcir.org/members or /donate. So we, of course, hope you all have an amazing holiday season. It's incredibly cold up here in Taos today and full of snow, and it looks like there's more on the way, which is just superb and fantastic. So let me now bring my introductory remarks to a close. And today, of course, we have our very sixth Rule of Law panel, where we explore all the various ways in which the current structures of rule of law are under some peril. And ideally, we hope that this incoming presidential administration will address some of those issues. And that, in many ways, is the theme of today's talk. So let me bring in our panelists today. I think you'll recognize all of them. This is, again, a wonderful journey we've been on with all these folks. And let me introduce them now in turn. So up on the top left of my screen, we have Rich Moriarty. Good morning, Rich. And Rich is a former Assistant Attorney General in Wisconsin, among many other things. And his insights are always just so appreciated. On the top right of my screen, I have Chuck Case, who is a former federal bankruptcy judge and the chair of the board of directors for CIR. Then we have Richard Silver, who is a former attorney who worked in many different ways, from the State Department to I want to say Treasury, and Richard, you'll correct me if I'm wrong on that, but Richard, of course, brings an invaluable global perspective on rule of law. And then our moderator for today is the one and only Ambassador Vicki Huddleston. So good morning, everybody, and welcome. And Vicki, let me turn it over to you once I say one more thing, which is, please type your questions, as always, into the Q&A box, and we'll get to the Q&A at about 11 o'clock. We're going to go for an hour and a half today, even though in the future we'll be pretty much restricting ourselves to an hour, as I think that's kind of the sweet spot for live streams. But today there's so much to say that we don't want to limit any conversation. So Vicki, good morning. Let me turn everything over to you.
Hi, Sandy. Thank you. Good morning, everyone. As you can see, I'm all decked out for Christmas. So I hope that you all are ready for the holidays as well. I'm excited about it because I'm looking forward to a much better 2021. And also, I think we're going to have a few rule of laws in 2021 as well. Today, our last rule of law, we've made it up to number 6, is really going to look at the elections themselves, because we're still holding our breath, but we're just about there. The courts do include the Supreme Court, the legislature, the executive branch, and pardons. That's a lot to cover, but as you know, we have these great panelists and they can do that very well. But it has been an incredible 4 years. The American people elected a man with no civilian or military experience in local or state or national government. And this man, President Trump, then began to defy and to bend the norms that traditionally presidents have respected. I immediately, because I'm foreign service, think about how he has attempted to bend the executive branch to his will, whether it's justice, which was the most notable, but also the State Department defense with numerous changes, removal of senior people. And I think in some ways, one of the things that disturbed me the most was that when the bureaucracy did not agree with him, then he was quite willing to denigrate it to our allies as well as to our enemies. One remembers the famous meeting with Putin and President Trump saying that he agreed with Putin, not the intelligence agencies. But he has also bent the norms in regard to tax returns, not allowing those to be revealed, as well as conflict of interest for himself and for his extended family. But the gravest threat was indeed, and still is, his refusal to admit that he lost the presidential election. And it is grave, as Senator Chris Murray said on the floor of the Senate, and a threat to our democracy, not just because President Trump says it, but because over 100 members of the House of Representatives joined him in a lawsuit attempting to overturn the will of the people. So I'm going to start by putting our constitutional specialist lawyer on the spot, Rich Moriarty, and asking him what steps our country should take to ensure that no matter which party in power, Democrat or Republican, how can we make sure that the will of the American people is not overturned? Rich?
Okay. All of the things you've talked about, oops, I'm getting an echo. Is that out?
All right.
Okay. All the things you talked about, merit reforms, and I think we're going to talk about that in future rule of law sessions. But the election issue is as critical as you say. There's a lot of reforms. Let me mention just three. First, the Electoral Count Act of 1887. That resulted from the 1876 fiasco, where basically a lot of games playing occurred, and we finally ended up with a president through rather faulty means. The 1887 Act, experts look at it and say, I can't understand this. I can't understand what it's saying. That governed many of the problems that we see now. And that is vote certification, primarily. How do votes get certified? What's the process? We need to have Congress go right on in and really look at that Electoral Act, clean it up so that we don't have all of those somewhat technical problems, but critical problems as we saw in this election. The second thing is transition. A transition should never be given to a partisan person. It should be moved to a nonpartisan role, somebody who calls a true referee who says, now we have a president and here's who it is. And now the transition may begin. That's an easy one that I think both sides, both parties should be able to agree on. The big one that I have concerns about is the Electoral College generally, and the fact that the state legislatures do have the authority to, the constitutional authority to pull back, if it's done well in advance of an election, to pull back and say the people's vote is merely advisory. We get to decide after the election who gets the electors. They couldn't do it in this election because every state in the union had, prior to the election, designated the people's vote as the one that would control. But coming up in 2024, you could well see Republican legislatures changing that and turning it into advisory. I'd suggest taking the Congress acting under the spending clause, tying it to federal funds, getting states' consent to make sure that the popular vote always prevails as far as who are the electors. We could talk about that more later if it comes up.
I think that's pretty scary.
Yep.
So we have half of the states or more decide to say that, oh, well, the people's vote is advisory, and if we don't like it, we're going to appoint our own legislators. Woof, or electors. As legislature, we will appoint the electors.
Fairly undemocratic, yes.
Yeah, I mean, one way to make the election even more undemocratic than it is.
Right, exactly.
Well, Chuck, what I'm hoping that maybe you'll talk about as a judge is this Supreme Court case, because I have to say that worried me almost more than anything else, because I was not sure if the Supreme Court took the case, whether they might decide in favor of Texas, given that 3 court judges were nominated and put on the bench by President Trump and the Senate, and that 2 others are very conservative. So what do you think?
Well, Linda Greenhouse in the Times this morning has a wonderful column on this subject, which is "Thank You, Supreme Court, for Now," in which she talks about a number of these things. So I'm going to steal a little bit of what she had to say. Without getting too much in the woods, it's an interesting thing. This is what Texas tried to do, was to invoke the Supreme Court's original jurisdiction. The Constitution says that when a state sues another state, then the Supreme Court has original jurisdiction, which means it's like a trial court. We know the Supreme Court never takes evidence and doesn't know how to. Very few of them have ever been in a trial court, frankly. And these cases usually involve arcane things such as water rights. Texas versus New Mexico was just decided this year, 2020, in December, after decades, literally back to the 80s of pending, with a special master called the River Master, who actually did all of the factual development. That's the way these cases normally go with original jurisdiction. Usually the Supreme Court decides cases that have been decided in another court. But Texas didn't want to do that. So Texas filed its lawsuit directly in the Supreme Court. And the Supreme Court said, you know, sorry, but you don't have standing. Now that's a term that we've kicked around a lot, and it derives from the constitutional requirement that courts, federal courts, can only decide cases or controversies. Those are the magic words. And that has devolved over the course of time into this notion of standing, which means you have to have some justiciable, some injury that can be determined through a court that is personal to you before you can come into the court. I was reading some comments in the Washington Post to an article, and I ran across this one. It said, well, I'm not a lawyer, but here's how I understand it. If you are Tom and want to take Dick to court for cheating Harry, the Supreme Court says you can't do it because it wasn't you, Tom, that got cheated by Harry. And that's what we have here. Or his more colorful example was, imagine if Joe Blow in Kokomo wanted to sue the girl from Ipanema on behalf of the men who turned to watch her passing by. Well, Joe in Kokomo doesn't have an interest in that lawsuit. But nevertheless, that's what Texas was trying to do. The question was, what interest did Texas have in how Pennsylvania counted its votes or ran its election? Pennsylvania, Georgia, Wisconsin, all of them that were defendants. The notion being, Texas said, hey, it hurt us because we have stricter laws than they do, and that means more people get to vote there, and that hurts us. And the Supreme Court, not surprisingly, kicked that out. Even the 2 who said that they would have at least heard the case, which is Thomas and Alito, also said they wouldn't have made any ruling in favor on the merits. That was, again, strictly a legal argument over whether or not the Supreme Court has the discretion not to take a state versus state case, or whether they're mandated to do so. And just to focus on what Rich said, the specific language in the Constitution upon which the theory of the Texas case rests was, quote, each state shall appoint in such manner as the legislature thereof may direct a number of electors. That's from Article 2 of the Constitution. And that's what all of these fights have been about, saying, hey, it's really the legislator that gets to do that. My final comment will be on this question, and we can always come back, that I agree with Rich that the state legislatures have the ability to have the power to do what he is suggesting. But you can imagine the political blowback in any state where the legislature says, our position is, voters, you don't matter. We're the ones that matter. Even in conservative red states, it seems to me that would be politically untenable. But that doesn't mean they wouldn't try.
Rich, do you agree with that?
I think the political blowback would be immense, and the issue there would be an assembly, a state assembly, which runs every election, the entire assembly generally, saying in March, hey, in this upcoming election, you got no vote. You're just advisory. Then they run again, they themselves run in November. I think the political blowback would be intense. However, I think Congress needs to address the issue and try to get a uniform system where you've done it for years. Popular vote is the key. That's what we're going with here.
Yeah.
And just to be clear on that, every state today has a statute on its books that says that the state's votes, electoral votes, will be determined by who wins the popular vote in that state. In effect, the state legislature has determined, that's the manner in which the legislature has directed the number of electors that they're going to have.
And
so
has since the 60s.
That would have to be changed.
Mm-hmm. Yep.
And that's the reason, it's one of the reasons why all of the talk about let's kick this over to the legislatures would have required, in effect, overruling, revoking, annulling a law that was already in place in favor of a new law that said, we can just decide who it is.
Okay, let me just add to that. It would have been unconstitutional under a decision of the Supreme Court last term. Well, indirectly, but in any event, had one of the legislatures done what Trump wanted and said, I know we said the popular vote would prevail, but now we're going to do it, that would have gone to the Supreme Court. And I think all of the justices, possibly one or two, all of the justices, at least a majority, would have said that's unconstitutional. You cannot retroactively override the popular vote.
Yeah, that case you're referring to is the faithless elector case.
Right.
That was decided. The one where the issue was, could states punish electors who decided on the day, in this case, December 14th, they were going to vote for somebody else other than who it was.
Yep.
And we also know that some of the states have decided, two of them specifically, that their electoral votes would be allocated in accordance with their congressional districts. Mm-hmm. And that's Nebraska and Maine. Mm-hmm. And actually one district in Nebraska was the first one that when they were counting that got Biden from 269 to 270.
Mm-hmm.
Yep. I guess we probably should just go ahead and talk about the Electoral College for a minute. We're going to get to you in a minute, Richard, and the international aspect of this, but the Electoral College, shall we just get rid of it? And if so, how?
How is a constitutional amendment which would require 2/3 of each house of the Congress and 3/4 of the legislatures. So I think my numbers tell you you're not going to get rid of the Electoral College anytime soon. The Republicans will view the Electoral College as advantageous to them unless and until they win a presidential candidate who's Republican wins the popular vote and doesn't get the Electoral College.
You know, just like many things, Electoral College is a product of the 18th century. And the idea at that time that they wanted these well-informed citizens, read that as men, not men and women, to decide who the president was rather than having the president chosen by popular vote, because there was a distrust of the popular vote generally at the time of the election. Same thing was true with the Senate. The Senate was not elected directly by the people until sometime later. I don't know, Rich, when that amendment was. But this was a very 18th century notion that, you know, we will choose the wise men and we will trust them to make the decisions about who the president will be. And that's where the Electoral College came from. Then as states started to say, well, we're going to have these elections and the electors will be chosen by popular vote, then you have this disconnect between the 18th and the 21st century in terms of, you know, why does this make any sense? Particularly the winner take all aspect of it. I mean, when we remember 2000, the reason that George W. Bush was elected was a matter of less than 500 votes when the recount was stopped, and that less than 500 votes, if you had a popular election, would make no difference. But what it did was flip all of the Florida electoral votes from Gore to Bush, and that's what put him over. And the same thing was true this year. All those so-called swing states were winner-take-all swing states. The Constitution says nothing about that, which is why Maine and Nebraska can allocate their votes differently. And in fact, states could say, it would be to the disadvantage of one side or the other unless everybody did this, but states could say, okay, we've got 18 electoral votes. We're going to apply a percentage of the number of votes for each candidate and divide those 18 up that way. The way the Nebraska and Maine decided to do it was by congressional district. But it's the winner-take-all aspect of the Electoral College that is so problematic and leads to these notions or to these results where the winner of the popular vote gets more votes than the Electoral College.
Yep.
And the answer is yes, Vicki, of course we should get rid of it. But what Rich says is true, which is a constitutional amendment is a very heavy lift.
Yeah, especially when we have Republicans becoming a minority party and worried about that status and how to continue to be elected.
Right, and it very clearly benefits smaller states, because in the smaller states, not always, but usually tend to be the rural states, which tend to be red states. I mean, there are some, Delaware and Rhode Island come to mind, that are blue states, and that they, you know, that would affect them too. But generally, the resistance is from the Wyomings, you know, the Wyomings and the Iowas and the smaller southern states, smaller Midwestern states,
Yeah.
the Dakotas. I mean, all the Dakotas and Wyoming, remember, in Montana, have not only the number of representatives, but the 2 senators they get, which is what gives the extra weight to those smaller states that they don't want to give up because of the political power it gives them.
Yeah, like New Mexico.
Like New Mexico. I mean, New Mexico is a perfect example. Well, I mean, it goes on the other side along with Rhode Island and Delaware.
Yeah, yeah. Well, Richard, are you there?
Oh,
He seems to have dropped out, Vicki.
oh,
I was going to ask Richard about some international questions and how we look on this. Excuse me. I am going to now turn to the courts. And of course, I've actually been excited about asking this question to Chuck because we've discussed it before, but I've never actually said, Look, Chuck, with all your experience as a judge and in the law, tell me, how would you reform the Supreme Court?
Well, I'll note that Richard is back. If you want to ask him first, Vicki. If not, I'll address that, and then you can go back to him after that.
You should answer, Chuck.
Okay. Well, it's a very hard question. There's all sorts of ideas have been kicked around, all of which have to be considered under the canopy, or you might even say the cloud, the umbrella of the Constitution and what the Constitution requires. You know, the founders in their wisdom decided that they wanted to try to insulate the Supreme Court from political influence, and they did that through two provisions in the Constitution. Provision number one was lifetime appointments for judges who are nominated by the president and confirmed by the Senate. That's so-called good behavior. They stay on the court during good behavior, which has been universally interpreted from the beginning of our nation as lifetime. And the second is a little less well known, but it's also very important. It's called the compensation clause, that says that the compensation of judges cannot be reduced once it's set, so that it can only go up, it can't go down. So that Congress and the president cannot decide to punish the courts by cutting their pay in half when they don't like decisions that are being made. So between the lifetime appointment and the compensation clause, the impact was, or the intent was to insulate the court from political influence. But the results, frankly, in my opinion, have been perverse. What we have is as a result, the installation of young. Why young? Because they have lifetime appointments and they last for decades. Political, I think you can call them ideologues. And that has been a pathway that has really taken on steam. So as long as you have a lifetime appointment and you have Supreme Court justices that are nominated by a president who by definition will be partisan and confirmed by a Senate, which unfortunately is supposed to be the world's greatest deliberative body and has turned out to be a group of political hacks, and that's just kind of reality, you end up having this problem. And the problem is exacerbated by the randomness by which the court is constituted. You know, there's no 2-year term, there's no 4-year term, there's no 6-year term. 2 years for the House, 4 years for the president, 6 years for the Senate. The term is as long as you stay alive. And so as a result of that, you have this randomness that if a particular president gets to nominate and a particular Senate gets to confirm so many Supreme Court justices, it changes the composition of the court for decades. And President Trump, in his less than 4 years, has been able to install 3. And no president since President Reagan has installed 3, and he did so over 8 years, not 3.5 years. And some like Jimmy Carter didn't get to appoint any, and others like Gerald Ford, who was only president for 2.5 years, got to nominate 1. So it's completely random, and it really turns on the laws of nature, of who lives and who dies. As one person put it, as one commentator put it, looking at other countries, only in the US does the balance of so much national power hang on the ability of an 87-year-old jurist to hold out for a few more months against the ravages of disease and the inevitability of life's natural course, referring, of course, to Justice Ginsburg. So all around the world, there are term limits for Supreme Court justices. Some of them are 70, like in Italy. A good friend of mine just had to retire at 70 because He was 70. Most of them are maybe 75. Occasionally you'll get 80, but there's mostly 70 or 75. Judges are required to retire. And even in the United States system, there is a similar kind of protocol. We call it the rule of 80, which says that if you are a district judge or a court of appeals judge, in other words, any judge other than the Supreme Court who is nominated by the president and confirmed by the Senate, then you can retire and keep getting paid and not have to hear cases anymore or hear fewer cases when your age plus the number of years you've served equals 80. So 65 plus 15, 70 plus 10. You can take senior status, retire completely, semi-retired, keep working, whatever you want to do. But what it does is it frees up another space for whoever the president is then to nominate an active judge, who then becomes an active judge on the court and is involved in all sorts of things that the senior judges are not. So what about something like that? What about a term for the Supreme Court justices? Well, I think it only works if you do it by constitutional amendment. And this is a long-term solution. I talked about how hard long-term constitutional amendments are. That's true, except if you can figure out a constitutional amendment where each party is uncertain of whose ox is getting gored as a result of this, then it might be able to pass. So, for example, on the other hand, the idea of changing the number of justices that a particular president can appoint and say, oh, you're limited to only 1 or 2 per 4-year term. Well, now the Republicans will say, that's great. We've got our 3 in there. We want to limit what Biden can do, or Biden and any successor. This is a more long-term solution. So very quickly, my idea is, let's have a constitutional amendment that limits everybody to 18 years. And at the end of 18 years, that person's term ends upon the appointment and confirmation, nomination and confirmation of the successor. Well, what about those who have already served 18 years, which is a lot of them at this point, in the year that that constitutional amendment is passed? Let's say hypothetically it's passed in 2023. Start right now and let's get it done in 23. Well, then what are you going to do? Well, it seems to me that the way you kind of protect that is by saying that anybody who has already reached that threshold of 15 or 18 years, whatever it is, can serve until cannot be replaced until after the next presidential inauguration, so that at least there's some doubt as to who it is who's going to replace them. So it's the best idea I've come up with so far in terms of how to do it, and it's a long-term solution, but I think it would help structurally. The other one of using age limits, like most countries do, also has merit, except you would end up, as one commentator said, instead of getting Supreme Court justices appointed in their 40s and 50s, they'll start getting appointed in their 30s because of the same issue. They want them, if it's an age limit, they want to get them as young as possible. And if you have a compliant Senate, suddenly you have a 35-year-old justice of the Supreme Court, and you have the same problem. If you have a term limit instead, that justice is limited to the 18 years. Best idea I have, Vicki.
I love it. I think you should get out there and start it in New Mexico. Because it seems like something really has to be done about the Supreme Court. And I'm coming to Richard now that you're back, but I think I wanted to finish with the Supreme Court first. And what I'm more concerned about, I'm concerned about the Supreme Court because of its composition at this point. And so is the Supreme Court going to be as conservative as it appears, or can we hope that it's not going to be quite as conservative or partisan, given that they did turn down the Texas case, Rich?
The Texas case, I've thought about that if we, what we have is a Supreme Court and lower courts that turned away and rejected all these efforts to overturn the election with absolutely no evidence. What would have been startling is if we had a 5-4 decision or a 6-3 decision that turned that away, or lower courts, the headlines were, most of the lower courts ruled against these evidence-free cases, except the Trump appointees voted for. Fortunately, every one of the judges, including those appointed by Trump, with the diminished expectations we have, kicked out these cases. That's not surprising. It shouldn't be surprising. Going to the larger point, what do we now have as a Supreme Court? I wouldn't look at the Texas case, which was really judging 101. You don't rule for somebody that has no evidence. You look at the religious case that the Supreme Court decided recently, where New York had COVID standards that limited the number of people that could be in churches or places of worship. And by 5-4, the court reversed itself. It didn't do so explicitly, but it basically reversed its prior position from last summer, saying this is a public health issue. These places of worship are being treated as they should, as potential COVID spreaders, spreading places. People are there for a long period of time in an enclosed space, so we're going to say you only have so many people that can come in. Roberts had last summer ruled in favor of state public health over religious objections, and did so in this case as well. However, the difference was Ginsburg wasn't on the court anymore, Amy Coney Barrett was, and so you had the rejection of state public health controls for the benefit of religious quote unquote rights. There'd been a lot of careful balancing over the years. That is now, in my view, tossed out the window in many ways. And we have a majority of the court that is going to rule in favor of religious positions, regardless. I think the same thing will be said of a lot of corporate versus individual rights. You do have Gorsuch as an interesting case, somebody who ruled in favor of same-sex rights last term, and also in terms of in favor of Native American rights. But generally, we have a very conservative court that does not reflect anywhere near reflect what the country is now made up of, and they will be there for a long time, ruling in ways that, in my view, will be very contrary to the public view.
Richard, we have a couple of questions for you. Thank you, Rich. I think the first is if you just comment in general on the perception of the U.S. elections abroad. I sort of myself think that the perception of our mishandling of COVID is actually worse than the elections, but it would be interesting to hear your take on that. And also, I think domestically and internationally, it seems as if the president may be salting the earth for President-elect Biden. I was thinking in particular about the Israeli killing of the Iranian nuclear scientist. There are several other issues in the international area you might want to address. So over to you, and your microphone's not on right now.
Well, good morning, everybody. Thank you very much. It's a rich series of questions you've answered, Vicki. I'll try to be brief and systematic. Beginning with the last question you asked about salting the earth or last minute. efforts made to change the foreign policy environment. I think it's perhaps a way to think about it, or maybe some proxies for understanding this, is to realize, first of all, it's not entirely any one thing. The Trump administration does not seem to have had a really clear foreign policy, and it applies in ways that are sometimes in line with American tradition and other times to deviate from standards that we've had. And I feel we could look at a few examples briefly as I toggle to the other part of your questions. Those are the last minute actions, with respect to withdrawal from Afghanistan and other withdrawals, which include Iraq and Somalia on the one hand, and then also this rapid succession of normalizations of relations between Israel and different states. Now, with respect to this trend towards normalization, we could look at the situation of UAE and realize that in essence, the normalization reflects activities that were already existing. There was already reasonable yet under the radar interactions between the UAE and Israel. And the US used the opportunity to sell advanced aircraft to the UAE as part of the process of encouraging this normalization. In some ways, it is in line with many Trump administration actions to sell advanced equipment, which we've also done to the Saudis, and to have a diplomatic breakthrough in line with things that were generally occurring can be seen in some ways as forward-leaning and uncontroversial within the context of Trump foreign policy. Similarly, in the case of Sudan, and I conferred with former Deputy Chief of Mission to Sudan, our board member, Marcus Guino, about the use of taking Sudan off the terrorist watch list to facilitate the establishment of diplomatic relations with Sudan. Mark felt it was long overdue because the dynamics of Sudan, where the former dictator Bashir has departed and Sudan has placed in escrow sufficient funds to compensate victims of prior terrorist acts. So again, something very non-controversial, well within the parameters, and it facilitates a legitimate US foreign policy goal of having greater diplomatic relations between Israel and members of the Islamic world. On the other hand, on December 10th, the US recognized Morocco's sovereignty over the Western Sahara, also to facilitate Morocco's recognition of diplomatic relations with Israel. Now, this is something that is clearly a last-minute departure, and significantly, the conflict in the Western Sahara and Morocco has been going on basically since the late 70s, when the Western Sahara was returned from Spanish sovereignty to local dominion, a time when there was conflicting sovereignty between Morocco and Mauritania over the Western Sahara. The UN has since that time acknowledged local independent sovereignty, and while there's a long history, what is significant is just as recently as November, there was armed conflicts between the independent movement, the Polisario, against Moroccan sovereignty. So when we, in December, acknowledge Moroccan sovereignty over the Western Sahara, we are doing so in the context of a nearly half century of conflict that is active and inflamed and current. So unlike the cases of UAE and Sudan, we are again doing a similar kind of facilitation of the establishment of diplomatic relations, only we're doing so acknowledging what some might say is the changing of borders through the use of force at a time of active conflict. And this will run contrary to the general positive trend because it will inflame passions across much of the world who likes to see the establishment of new diplomatic relations in the context of non-controversial land grabs. Flipping to Afghanistan, we've been negotiating with the Taliban for some time, and part of the agreement that we established with the Taliban primarily and the Afghan government secondarily has been the reduction of violence and the insurance that Afghanistan would not be used as a base for terrorist activity. Moreover, it was contingent upon a reduction of violence and the non-safe haven for Al-Qaeda. Now, what has occurred is a continuation of violence in Afghanistan and an indication from the Taliban as recently as this week that they are going to honor their historical commitment to Al-Qaeda. So the conditions upon which our peace process was based are being violated by our counterparty, the Taliban, at a time when the US nonetheless
A little frozen.
Richard's connection is not good, but thank you, Richard, for that. It just what I think about so much on this is that all of our presidents until this one have abided by the idea of international law and alliances and an order in which each state, each country had a legitimacy. It wasn't just to be sold off to gain some temporary advantage. And what we have seen, if nothing else, in the foreign policy of President Trump is purely transactional, whether it's arms, whether it's getting off the terrorist list, or whether it's undermining a country's desire for sovereignty. But I could go on and on. Let me get back to the U.S. domestic issues, and the one that I can't wait to get to because Sandy has a photograph that I want to take a look at, and that's about pardons. And can the president pardon himself? I'm sure he could pardon his family. The question is on that. Can he pardon them before he knows what he's pardoning them for? But Sandy, do you have that picture there? And then if you do, I'll turn to Rich or Chuck, whoever wants to jump in first, about whether the president can pardon himself.
Can I, Vicki, can I make a quick comment about reform of the Supreme Court before we move on?
Yeah, please do.
Just a couple of points. It's interesting. We wonder, why do we have lifetime appointments now instead of 18-year terms or age limits? It's because this has never been changed in the Constitution. And in 1787, people didn't live as long. The idea of 85-year-old justices didn't occur to them. In fact, Hamilton said, I don't want to put anything other than good behavior in here because there is really no risk of a, quote, superannuated bench, close quote. Those were Hamilton's words, because people just didn't live as long. The second thing that's really interesting was in 1954, the Senate actually, by a wide margin, approved a constitutional amendment that would have forced all federal judges to retire at 75. 1954, what else happened that year? Well, days later, the Supreme Court decided Brown versus Board of Education, and the whole focus on the court moved away from that idea of limiting rather to the question of desegregation and the fight over desegregation. So it has come close before, but then the circumstances, historical circumstances, made it a secondary issue.
Let me make a quick point on that, Chuck. in the 1700s, late 1700s, the founders were undemocratic in many ways, as we've also already talked about, and creating these lifetime appointments was part of it. By the 1830s, many of the states had lifetime appointments as well. By the 1830s and 40s, nearly all the states had gotten rid of the lifetime appointment issue. We're stuck with this Constitution that's so hard to amend. That's the problem there.
Right, I agree.
If I can just insert a parenthetical here. Toggling to the international, I just want to note that when we have our elections, that is one of the key moments when the world is watching most what's happening in America.
Mm-hmm.
And I had some of my former staff members in different countries from my foreign service days contact me when Biden won to talk about the restoration of American values, the importance of American democracy for the rest of the world that sees us as a beacon of hope, particularly former colleagues in Eastern Europe. And then in the course of this contesting of the election results, I had the same people contact me indicating how crestfallen they were. So as we look at our own judicial process and Supreme Court reform, everything I think we should understand in our rule of law discussion is part of the strength of American democratic institutions. And there's none more sacred than our electoral process. So I have a lot more to say on this from the international perspective. I apologize for my screen cutting out, and I know that's interrupted the flow. And for that reason, I'll return it back. But just wanted to make that, to underscore that point, that this is the moment when the world takes its cues of peaceful transition of power, the importance of the American system, and it causes people to reflect on their own system and the own ways in which their citizens look to us as example, and they take their cues from the way their own political leaders look to the way we are doing things and the way they congratulate or do not congratulate as a reference to the status of American democracy at this moment. Again, a lot more to say. I turn it back over to you for brevity's sake.
No, thank you, Richard. Well, what I'll be looking for is, a lot of countries have become more autocratic, less democratic during this time, as the United States has as well. But now as we turn back toward our old norms of democracy, human rights, will we see some change internationally? Hopefully we will. Pardons.
Pardons. Can the president?
10 minutes. Let's
Okay.
give this a
Can
good
the president self-pardon? That is a big question, which goes right to the rule of law. Whether or not a president who has the authority without qualification under the Constitution to pardon, can he do that for himself? I think that should President Trump try to do that, that is something that can be challenged in the Supreme Court, and that he would not find support there. In a case last summer, all of the justices, they were dissenting and those supporting it, all talked about the rule of law. That's in the subpoena case, Trump subpoena cases, that a president is not above the rule of law. All of them agreed on that principle. They differed on a lot of the ways they went at it. But I think that would bring it right to a head. Can a president pardon himself? Excuse me. That is putting the president above the law. So I think that would be a major mistake should Trump try to pardon himself. I think what you'd end up with is the smarter move. I'm not saying that that's what would occur should he go that route, would be to resign, even temporarily, pull back, allow Pence to come in and pardon him, and then maybe pull back the presidency. That's another option that he has. There's another big problem, however, that commentators have been looking at. The pardon power, when you look at originalist thinking, was supposed to be specific to the crime. You are supposed to specify What crimes are being pardoned? That's never been challenged. It came up in Watergate with Nixon being pardoned for whatever he might have done, but no one challenged it. Should that be challenged, there's a good argument based on originalist thinking with all these Supreme Court folks that you must be very specific. What crimes are being pardoned?
You know, the jurisprudence on this is pretty clear that the whole pardon power derives from the pardon power of the English crown. And the early Supreme Court cases talk about that. And so if you fill that in and say, would the king pardon himself? You know, it seems kind of ludicrous. That's one thing. Two other points to make. Number one, what the pardon power says in the United States and in the Constitution is that the president has the power to grant a pardon. And there has been some discussion in the literature about whether that implies necessarily that a third party has to be involved, or a second party, in effect, has to be involved. Can the president, does the word grant necessarily imply that you are granting it to somebody else as opposed to granting it to yourself? And again,
like those two right there. Yeah.
Yeah, no, exactly. Like, you know, the originalist idea is that it would never just be a single thing. The second point I want to make is that this issue, second of three, is that this issue that Rich just brought up, that it's never been decided, was specifically avoided in the famous 1915 case of United States versus Burdick, when they said, one of the parties wanted them to say, we want you to decide whether or not a pardon can extend to crimes that have not yet been charged or are not specified. And the Supreme Court specifically declined to answer that question because instead it based its decision on the idea that that a pardon is like a gift, it's a grant, it's an act of mercy, and that it has to be in effect accepted by the person being pardoned. And that if it is not accepted, then in fact, it's not effective. And this case came up in the context of a newspaper publisher who was being pursued, trying to reveal his sources about some corruption, and he was refusing to do so. And President Wilson peremptorily pardoned him so that he would be able to testify and spill the beans on this stuff. And he refused to accept the pardon. And the Supreme Court said, well, if you refuse to accept the pardon, then it's not effective. Why is that? Because a pardon, words from the Supreme Court case, a pardon carries an imputation of guilt. Acceptance is a confession of it. Pretty important concept. Those of you who are on Journalism Under Fire heard Bob Woodward tell the anecdote about how he asked President Ford, President Ford, you've been criticized for granting Nixon a pardon without his ever having been charged for anything or any specific crimes being enumerated. And according to Woodward, Ford reached into his back pocket and pulled out a piece of paper from his wallet and read the words I just read, that a pardon carries an imputation of guilt and the acceptance is a confession to it. Now, if that's really the law, does Rudy and Ivanka and Jared and the rest of them, do they really want to admit, confess to a crime or to having committed crimes, thereby accepting the pardon? Does the president want to do that if that really is the law? You will note, for example, Roger Stone's sentence was commuted after he was convicted. He was not pardoned because he didn't want a pardon. He didn't want to accept the guilt that came with the pardon, but he wanted to get out of jail. The same thing could happen to Manafort, for example. His sentence could be commuted and he would not have to accept a pardon and accept his guilt. So anyway, there's lots of open questions on this. And as long as Burdick is there, good law from 105 years ago, there is this real risk that if you accept a pardon, you are confessing to a crime.
Oh, you're muted, Vicki.
Should we prosecute, should the Biden administration to attempt to prosecute President Trump and those around him, or is this just, dragging on something that's going to, in the end, taint his own administration?
Richard,
Well,
why don't
before
you
my-
jump in and I'll come back? Yeah.
Yeah, no, thank you, because I apologize again that I keep glitching out, but the first overarching point, I think that we should look at this through the lens of preserving the integrity of our democratic system and institutions. I also think it's important that we not apply normal standards to abnormal situations. And I feel that the ordinary view that you don't prosecute an ex-president is a norm. And we have a norm-busting president, and the debate is around whether we should apply a norm to this norm-busting president. And so the first thing I'd like to look at is all of the things that are potentially criminal, are a couple of the potentially criminal things that go to the integrity of our elections committed by Donald Trump. If you look at the Michael Cohen prosecution related to the Stormy Daniels scenario, essentially what it was a campaign finance violation. He was trying to get negative information that could influence the public related to their vote to him getting into office. So the crime that he is alleged to have committed directly goes to his ability to get into office. And then the question is, should you be free from prosecution if you got into office by using illegal means to get into office? I think the answer to that should be no. Similarly, for the legal nerds on the panel and in the audience, if you look at 18 USC 595, it is a federal law that prohibits the interfering in elections by government officials. And if you look at the various actions like calling state legislators to the White House to persuade them to take anti-democratic actions, or to filing lawsuits for which there is no evidence repeatedly, and then getting others to try to take actions that would overturn the will of the people, I think there's a very strong case to be made that that's a violation of 18 USC 595 for interfering with an election, going to the heart of our democratic process. Moreover, if you look at the underlying context for impeachment, it was trying to get a foreign government to to interfere in our elections. Now, all three of these things go to not only the integrity of the electoral process, but the perception of American democracy, the willingness of people to accept American democracy at home and abroad. And I feel that bringing prosecutions, which I believe Biden shouldn't do, I think an independent attorney general should have the freedom to undertake an assessment about whether it's appropriate to ensure that our democratic standards, our constitutional language and values, and our federal statutes related to the election are upheld. This is different than trying to do what Donald Trump has done during the last weeks of the election, which is to say that his political opponents should be prosecuted. This is standing up for American democracy. And I think that prosecution should not be off the table if we want to preserve a non-autocratic, live by the norms, let the chips fall where they may in ensuring that the will of the people is carried forth. Rich, if you have another side to that argument, please feel free. Thank you for listening.
I'm going to jump in here. I'm sorry, Rich, because we have to get to the questions.
Okay. All righty.
We have a lot. And Richard was very impassioned on this.
No.
But I have a question on chat. So I'm going to go with that first, and then I'll turn it over to Sandy. And I think you'll get what you want to say in there anyway, maybe even in response to this. But I had a note from Margaret Pearson who says if there were a case to be made for treason by Trump, would that be pardonable? I guess he would have to have Pence maybe in the presidency at that point, but I can see it as a legitimate question given his relationship with Putin and with Russia.
It's a good question, and what that goes to, and I don't have a clear answer on that, I think, but treason is one of the few crimes mentioned in the Constitution itself. So maybe that might make a difference. But I think if, for example, Pence were to pardon Trump, he could specifically say, oh, that crime of treason, yeah, you're pardoned for that as well. And that probably would stick if Pence did it. But he'd have to be specific. You'd have to really, I hadn't heard that one before. That's a great question. Let me just quickly say that on the prosecution part, I agree completely with Richard's diagnosis. I don't think it would be wise for the Biden administration to engage in prosecution, leave it to the states. And one big reason is we have such a toxic political situation right now with so many critical issues, climate change, many things, even within the Department of Justice that must be addressed, that focusing the Trump supporters and the Republicans on whether Trump is being prosecuted, unfortunately, would create too much. I would appoint an independent commission by respected bipartisan people to study and report on what the Trump administration did.
I don't even know whether I would do with that because here you have Biden right now doing his very best to reach out to the Congress, notably the Senate, because he's going to need them to get his cabinet approved. He's going to need them. He's going to do anything on climate change, even on COVID. So it's a tricky business to get into this. But it's over to Sandy for questions now.
Thank you, Vicki. There's a bunch of questions here. I'm going to try to group them together. The first sort of set of questions is really around that famous American institution of the Electoral College. And I wonder if maybe Rich, I'll pitch this one to you. We have the national popular vote movement where states are signing up to be effectively sidestepping the Electoral College. And from my read would absolutely be the death knell of the Electoral College if 270 votes from states commit to the national popular vote movement. Is there hope for this movement? What do you think about the future of that as a way of rectifying, the oversized influence of the Electoral College?
Yeah, we've talked about this in prior rule of law settings, and I think Chuck has a thought on the compact clause and whether that creates issues. In other words, the Constitution saying states can't engage in compacts. I don't see that problem. I think the national popular vote movement has the hope of defanging the Electoral College and assuring that the popular vote controls. It is short of the votes. The number of states involved now is short of the votes needed in order to do that. And it's got a ways to go, but that is one idea that doesn't involve a constitutional amendment and really could matter. Then it would go up to the Supreme Court whether or not this is valid, and we'd see what the various folks thought there.
Well, connected question, that's really a constitutional issue. So maybe Rich, I'll stay with you before going elsewhere. This is a great question from Irene Thomas that I think all of us have been thinking about. What were the founders thinking by creating a long lame duck session? I don't think any of us could imagine a vindictive president who would want to cause mischief in that period, but why in the world? I can't think of another democracy that has a similar lame duck period. What was the intention behind that?
Initially, the 13 colonies were laid out along the coast of the eastern seaboard, and travel was difficult within the country. Roads were often washed out. You had an enormous delay in people getting from one part of the country to another frequently. And so that was the main idea, I think, that the founders had in creating the delay. And initially, it was until March. It was from November until March. And then that was changed, and I can't remember the year now, but it was changed in the 20th century to January and shortened up, but still far too long at this point when we have instantaneous communications and electronic communications. So that might be something that could be a change that wouldn't create any gored oxes in either party to shorten that time period up. So maybe you could have a constitutional amendment on that kind of issue.
Yeah, it was March 4, and now it's January 20, and it's another norm. I mean, the norm was that Congress packs up and goes home in after the election in November, and they come back and start a new Congress in the first week of January. They take the holidays off. The president, once they're back, the president gets inaugurated later on in the same month. It all seemed to make a lot of sense. It was unusual for there to be lame duck sessions of Congress after the election. And the election was set up in November for many of the same reasons that Rich just talked about, except it specifically had to do with the harvest. You know, it was, okay, how long, you know, when's the last harvest going to be so that the farmers would be able to vote, and let's do it on a Tuesday so that they can, you know, go to church on Sunday and then get to the voting place on Tuesday. I mean, that's why we have the second Tuesday, you know, the first Tuesday after the first Monday is what it is in November. So these are all 18th and 19th century reasons for having these things. And just like the Electoral College, they survive.
Well, I was going to ask Richard a question, but I'll come back to that in a second. Maybe, I know I've asked this in previous rule of law sessions, but I have to ask it again. I think one of the great gifts of the Trump administration is illustrating, shining light on all the ways that American democracy needs to be updated for the 21st century. And maybe I'll just ask each of you in turn for, you know, what's one particular rule of law issue that you think, you know, the Trump administration has really illustrated needs that updating, and what would you do to change it? Who wants to jump in first?
Oof. I can't choose one. There are so many, I'm afraid. But I do think the 2024 election and the havoc that can be created by the Electoral College cries out for reform. If we had a crunch in 2024 where state legislators could override the popular vote, politically crazy as that might be, it could happen. I think that would create a crisis in this country far beyond some of the other crises that have been highlighted here.
My suggestion would be to have some kind of, and you have to be careful about this, some kind of national standard relating to elections. And the national standard would relate to things such as mail-in and absentee voting, early voting, when you can start counting ballots, and all of those things that now vary from state to state. I would not make it subject to a centralized database because that's much easier to hack than having all these diverse databases. But now you literally have, I can't remember the number, 4,000, 10,000 different agencies that have some control over the way an election is a federal election. I don't care, they can do whatever they want to with state or local elections. But a federal election, you know, sometimes down to the county level, one county will say, yes, you can correct your signature if it doesn't match. Another county says, no, you can't correct your signature if it doesn't match. And these are two counties next door to each other. This is crazy. I mean, there should be, for federal elections, some kind of national standard for how elections are handled, and also what kind of technology there is. You know, if they're going to require paper ballots or a paper record of some sort. But in any event, do that without necessarily centralizing the whole system so that it's more subject to cyber attack.
I don't see Richard, so I'll say that I would like to see some order in our alliances and in our treaties. President Trump withdrew from the climate change treaty as well as the treaty with Iran and our allies and even our competitors, Russia and China, on nuclear agreement with Iran. And we just walked away from these. And I think that gives a very serious inconsistency to our international relations. So I'd like to see something done on the treaty front, whereas when we enter, we have to go in the same door and come out the same door, and the next president can't just annul it. I see that you're there, Richard. Do you want to add?
So it's a tricky thing in national law, because we have to look at the fact that there's both national law as with the Iran nuclear agreement that became part of the UN. There, can you outside?
Richard, maybe just turn off your video.
Am I back?
Turn off your video, Richard.
Okay, I'm going to go video. Hear me? Can you hear me?
Turn off your video.
Okay, so under international law, there's going to be, for example, with the Iran nuclear deal, it became part of the UN Security Council resolution. And so there's a separate process there versus our domestic process. And so the tricky thing is many agreements become executive agreements and treaties, which require 2/3 confirmation. And so there's no single standard that you can create that binds a president, but the obvious harm that results from not being able to rely on an agreement once made by the United States means that we will no longer be seen as an effective partner. So we have a very critical need to come up with some legislative standards that would support our capacity to give comfort to third parties that we are a reliable partner.
Well, I have to say, one of the rule of law changes that I think we should all be deeply troubled by are the national security clearances given, to Jared Kushner, for example, and I would love to hear more details about, I forget which Middle Eastern country came in to help prop up 666 Park West. But then also, that dips immediately into tax returns. And I just can't imagine when we find out, and we will find out, especially through the actions of Cyrus Vance in New York, of President Trump's, financial obligations abroad. To me, that just seems absolutely shocking that hasn't rocketed to the very top of things in which a president or, presidential administration have to satisfy those boxes before they're given essentially the key to the intelligence kingdom. So hopefully we can get into there's so many issues, but that one certainly jumps out.
And Sandy, what you're saying there is, again, an issue Republicans and Democrats could agree on. My God, if you're nominated, you must disclose your tax returns. I don't think that's going to be something that, once Trump is gone, will create political problems.
So a couple more questions about the Supreme Court, and a good one here from Barbara Chatterjee. In terms of the Supreme Court composition, is a possible, amendment looking at regional representation within the composition of the court?
I don't think that's possible without a constitutional amendment, because currently the president has the right to nominate and the Senate has the right to confirm. So we'd have to, we would have to overhaul our entire judicial system to have it reflect more what the 21st century looks like. I personally think that's a really good idea to have, and I hate people talk about commissions, but to have a blue chip commission look at this and say, here's the way we ought to reform the way our whole judiciary works. And I think that would make a lot of sense. There's another question I saw here that's sort of on a similar question, which Tom Johnson asked, for example, don't many other countries have separate education tracks for litigators and jurists? And the answer is yes, that's very common among civil law jurisdictions. We are a common law jurisdiction. We in the UK, Australia, New Zealand, I think maybe India. In other words, think about the former Commonwealth. The other side, a whole different judicial system, is the civil law system based upon the Napoleonic Code, basically from the early 19th century. And in those countries, like Italy, for example, when you're a very young, Italy, Germany, you're a very young lawyer, you're a graduate, you either go on a lawyer track or you go on a judge track. Now, I've always not supported that because I think one of the benefits of switching from the lawyer track to the judge track is that you have experience as a lawyer. But on the other hand, you are focused from the beginning of your career and you kind of work your way up the ladder on the judge side, and you are focused as a judge and not as a lawyer. And it becomes much less political and much more, in effect, technocratic, where judges do judging and judges are not really making policy in any serious way. So, yeah, that's most of the world actually does it that way, because most of the world, all of South America, most of Europe, continental Europe, virtually all of continental Europe are civil law based systems that have those kind of separate tracks.
What kind of, we have a resignation of Attorney General Barr just the other day. We have obviously a new Attorney General coming in. We have some damage that's happened at the DOJ over the past, few years with, for example, attorneys resigning because they don't, believe in, the political mandates that Barr and others have sent through the DOJ. Two questions about the DOJ. Maybe I'll throw this to you, Rich. What does the new Attorney General need to do to restore the integrity? And I'm not implying there's no integrity, but to restore the kind of image of the DOJ. And then secondly, there's a question here from Marcus Guino. What are the limits the Biden administration has in reining in the DOJ's abuse of appointing special prosecutors in the final days of the Trump administration, especially related to Hunter Biden and all of the noise around that? So let's talk about the DOJ for a second, and Rich, I'll throw it to you.
Okay. It'll depend mightily on who the DOJ, who the Attorney General designee is. If it's, Doug Jones, he has not expressed, because of his constituency, he has not expressed a lot of anti-Trump views. If it's Sally Yates, she was fired by Trump. So the perception of what that AG designee is doing will be looked at closely. As far as what can that AG do to reinstate the rule of law, I think it will come down to some formalized procedures that AG puts in place, but ultimately it's going to come down to what is that AG sending as a message throughout the DOJ. The rule of law is back. We are going to be doing this. I remember when I was a Wisconsin Assistant Attorney General, having a change in the Attorney General based on an election. And the prior Attorney General had been somewhat more intrusive in the way he went about things. The newly elected one came in with the idea, hey, 90% of this department operates, they're civil servants. You do what you do, you're all professionals. Let me know if something comes up that you think I should know about that has political consequences. Otherwise, do your job. And I think that the difference between those two messages is something that that needs to be communicated. And Mark's question, maybe Chuck, do you want to handle that?
Well, I don't know. I'm not familiar enough with the special counsel statute and appointment process to know. But I mean, my guess is that a new AG could certainly slow down whatever is being done, and would have to do that in a way that doesn't appear and is not, in fact, too terribly partisan. If there is, you know, a legitimate investigation of Hunter Biden to take place, well, then maybe it should take place. But we know, for example, in the Mueller situation, that if these special counsels were appointed on the same basis, then you know, the real power lies in the AG. I mean, Bill Barr always said, you know, Mueller works for me and the report comes to me and I get to see it first and I then get to spin it and tell people what it says, as opposed to Mueller having a direct access to the public. So my guess is if it's the same statute, and I assume that it is, that it's a lot of smoke and not much fire. Unless the new AG, really believing in the rule of law, looks at the evidence and says, yeah, you know, the fact that Hunter Biden is the president's son doesn't mean that we shouldn't look at this if in fact there are egregious violations of law. So I don't, you know, I think immediately dropping it would send the wrong signal too, because it would send the signal that I am protecting the friends and relatives of the president, just like Barr did with Trump.
Yeah, and when you look back at Robert Kennedy, the brother of the president being appointed, that was a real problem. That created a lot of impression problems. The AG is not a lawyer for the president, and that has to be emphasized and reinstated as a principle. And you know, sure, if there's some issue there, regardless of whether there's an issue or not, if a special prosecutor is appointed, let him play it out.
You know, the model for this is Edward Levy, who was appointed by Gerald Ford after Ford took over and Nixon had resigned. And when you read about what should the AG do, Edward Levy always comes up. I mean, I don't remember his exact background. I think he was a professor at the University of Chicago, or he had been, I don't remember exactly, but he was universally respected and came back and had a very straight arrow, turn square corners kind of approach and reinstalled the notion of integrity to the Department of Justice. So what I think Biden should be looked for is this generation's Edward Levy.
Right.
So a few additional points, if I may. The first is that the independent counsel law expired. So you would not have a Ken Starr-like ability to follow a prosecution anywhere. And the special counsel law does reside underneath the Attorney General. So it's a much more limited scope thing. Moreover, the general reason to appoint a special counsel is when there's such a conflict of interest that the Department of Justice cannot oversee a prosecution. And so in the case of the Mueller report, it was because Barr had to recuse himself, and there was the firing of Mueller, which necessitated the ability to have a complete arm's length process. Whereas currently the Hunter Biden case is being operated out of the Delaware U.S. Attorney's Office, and there's no indication that it isn't being handled fully consistent with an otherwise normal prosecution, and there's no evidence of a conflict of interest. So while I agree with the other panelists that if it's appointed, let it play out, so there's no appearance of political interference, the fact is the establishment is a nakedly political act, which is not inherent in the manner in which special counsels are appointed namely to avoid conflicts of interest. Here, none exists.
Well, we are officially out of time. Thank you to all of our panelists, Rich Moriarty, Chuck Case, Richard Silver, Vicki Huddleston. You are all a great treasure and a treasure trove of information on these amazingly complex issues. I look forward to our 7th Rule of Law panel at some point in the future, and hopefully we'll have a lot less to talk about, or we can be much more specific in the ways that we do want to address the many issues that undoubtedly face the Biden administration in this transition period. So I hope you all have a very wonderful holiday season. We will rejoin our live streams on Thursday, January 7th. We will feature Vicki Huddleston along with Ephraim Isaac, who's an Ethiopian elder and scholar, and we'll talk all about Ethiopia and all the things happening in Ethiopia today. So join us then. In the meanwhile, have yourselves a great holiday season, and thanks once again to our panelists for taking the time. We really appreciate it.
Thank you all. Good holidays.
Thank you.
Happy holiday.
Bye, everybody.
Bye. Take care.